Working on sharing my screen. Here we go. Good morning, everybody. My name, like Jesse said, is Jared Schmidt. I've been doing farm continuation since 2003. I've worked with many different styles and types of operations, from the 25 to 30,000 head cattle producer to the million head fat hog producer to the 50, 60,000 acre wheat producer. Growing up in Northeast Iowa, I'm actually the grandson of a dairy farmer. My father thought dairy farming was too difficult, so he became a hog farmer. I currently don't do either one of those. I do have a small farm, and we raise white-tailed deer. And I still complain, just like any farmer, that they're probably not yielding what I want them to yield. Growing fast enough, getting big enough, and the harvest was not as plentiful as I wanted it this year. So with that, just a touch of background, educated here in Iowa, went down to Northern Arizona University for a graduate degree. I began my career as an educator, high school, then collegiate, college professor, coached football at the high school and collegiate levels. 3 kids, one plays basketball right after this. Appreciate you letting me be flexible with my schedule so I can do this early and hit the basketball game and bring home that victory. I want to make sure you know I'm not an attorney and I'm not an accountant. I don't do either one, which I find beneficial. I actually have a very good relationship with my clients and helping them navigate their attorneys and their accountants, and usually kind of play that quarterback role where I work and handhold with the attorney to go to or with the client to go to the attorney, to go to the accountant, to get blessings on the plan that we put forward. But we absolutely need those people in our process, and we need good, competent ones. So we'll talk a little bit more about that. Probably not telling you anything you don't know, but no tree and no family is the same. They grow up in many different directions. And that growth difference, that relationship between them, can cause issues. It can also solve issues. I don't want to put this in a negative light. We can definitely solve issues within the family. But I would say when you are there to solve those issues, things work better. We affectionately in our business call that the mom power, because mom's pretty much going to get what she wants. Doesn't matter. And when mom and dad are gone, the outcome might be a little bit different. Mom's not there to fix the problem. Mom's not there to grab somebody's ear and tell them how to take care of the problem. So the outcome might change when you're gone. I get the story all the time. I know everybody's families are great. All the kids always get along, but it is amazing to me how that get along starts to fail as mom and dad are gone. Sometimes there's dollar signs, money figures that get in the way. So a lot of the times what we're doing is we're planning for the worst case scenario, and we're celebrating the best case scenario. Our wills, our trusts, our documents, they often just make sure that we are not going to have failure. And when we do our planning, we want to make sure we have perspective. So this is kind of a funny little exercise. What I want you to do is I want you to take a sentence that nobody would, I'm not going politically correct or wrong here, but here's an unpunctuated sentence that everybody has a perspective on how to punctuate. These 7 words can mean a lot of different things. A woman without her man is nothing. What does that really mean? Let's throw a couple commas in there. Let's see what it means. A woman without her man is nothing. Now, a lot of you just turned off your screens. That's okay. I understand. But let's go the exact opposite. A woman without her man is nothing. So this would be my wife's favorite version. The idea is perspective changes everything. You have to have perspective from your point of view, from your children's point of view, from your spouse's point of view, from the cash flow, the business's point of view, and find a plan that works in all of them, or accept the fact that somebody's going to be disappointed. And that's okay too. We don't have to have a perfect plan for everyone. We have to have a perfect plan for you. What's the driving force behind the plan? So is farming a way of life? Here's a picture of my son. He's my youngest. This was taken a few years ago, and this was a way of life, a picture taken, the 2 of us. I like to grab him out of school a couple of days a year and go up and run the grain tender up at harvest. So This is a picture of us in the tractor moving corn. So farm that day is a way of life. He loves it. But sometimes the farm is work. And 30 minutes, 45 minutes after this first picture was taken, this second picture was taken. That is 800 bushel of corn dumped right down the middle of US Highway 218 in Northeast Iowa. There was a 5-gallon bucket somebody placed on the seat of the truck, and driving down the road as it exited the field, the buck fell, the handle caught the release, and dumped that grain all the way down the highway. So what kind of work is this? We spent the next several hours picking up that corn, and when the sheriff arrived, he told us it wasn't good enough. So I'm actually I would quantify myself as a street sweeper. I broomed a quarter mile of US Highway 218 to get that corn into the ditch because it was not safe enough to travel after we used the loaders. So sometimes coming back to the farm, sometimes operating the farm is a way of life, and sometimes it's work. What's the driving force behind your plan? Are you giving your kids a job? Do they already accept it as a way of life and it's something that they just want to do? And sometimes sometimes it's a choice to come back to the farm, and sometimes it's by default. Sometimes we've gone out in the world, found out we didn't like it, and we came back. So it's the place we came back. It's safety. It's what we know. And the outcome of our plan can be by default, and it can be by choice as well. So in our plan, what we have to do is we have to look at the outcome. Our plan is going to have an outcome that might not be the same for everybody. It might be specified and determined based upon cash flow. So are we outcome based, saying our goal is to keep this family farm together, to keep the operation together, to make sure it cash flows, to make sure it gets to the 1 or 2 or 3 kids that really want to do it, and maybe at the detriment of the kids that don't want to do it. Maybe there's a difference in inheritance. But we have outcome-based plans where we will get our result no matter what. And we have relationship-based plans where the future of the operation isn't necessarily the most important thing on our docket. Sometimes it's the relationship within the family. Sometimes we want to make sure everybody gets along, and we say, we want everybody to come back for Christmas even after mom and dad are gone. And if a relationship is severed in that will, often that's the generation Christmas stops happening between that family. So are we outcome-based or relationship-based? And I'm not telling you either one is wrong. I'm telling you one of them is going to be more prevalent in your plan than the other. And that's okay. It's got to reflect you. Let's ask their opinion. Let's ask them which one they would want. Let me caution you on that. It's not wrong to ask their opinion, but I'll tell you one thing about kids. I have 3. They're all younger. Many of you probably have young kids, some of you adult kids. But if I ask my 3 kids for their opinion, they'll give them to me, and they're not the same. That can become problematic because you can write one plan and I have 3 opinions. Which one of those opinions is going to be reflected in my document? Which 2 of them knows it's not their opinion reflected in that document? So be cautious when we ask opinions because you might get them. And we don't want the first time that they read your opinion, find out that it's different, to be in your will. So we talk about when to share and when to sit the family down and talk about it. Family meetings are a vital part of this, helping them understand. A lot of times in family meetings, what I do is I say, cross out all the numbers, because all those numbers are different tomorrow when the wrong farmer moves into your neighborhood and starts buying ground at too high of a price, when the next farm went bankrupt for another reason and we see availability of assets at a discounted price. So things change every day. We live a lot longer than we want to live sometimes. We live not as long as we want to, and we spend into our funds. Those funds are then more available or less available to help our outcome. So getting those opinions can be a roadblock. So here's a couple other roadblocks we run into. These are the reasons people don't even start. I bet these are the reasons some of you haven't started. So first of all, you don't know your options. You sit down and say, well, we know we want to keep it in the family, but what do we do? I mean, What can we do? Can we get a will? Can we get a trust? Do we know about the different types of trust? If I start rattling off trusts, I might get to a dozen different types right now. And even if we decide the different documents we need, entities, wills, trusts, buy-sell agreements, do we know who we can trust to do it right? We have a lot of conversations about specialists. The legal profession doesn't seem to have it down quite as well as the medical profession. If you walk into your general practitioner and say, yeah, gosh, I just have this pain upper left chest and I'm just not feeling right, and I got this pain, he doesn't lay you back on the table to find out what's wrong. You go immediately to another doctor, a cardiologist of some sort, likely. And then if that goes bad, you go to an operating room, and they continually push you to the specialist and narrow down your doctor to the person who does that particular procedure all the time, most successfully. In law, that general practitioner handles all of it. We don't have to go away from them. They can do anything. Read their bios, look up an attorney on their website and read what they specialize in. You'll find a paragraph longer than this presentation of everything they can do, some of which they do very well and some of which they've never done before, but they are legally authorized to do them. Sometimes we don't have time. This is down here in Iowa, growing up in Northeast Iowa. There are 2 times of the year where I don't get to talk to any clients, which they correspond to my family vacations. But you get into planting season, everybody disappears. Now, every now and then I'll get in a tractor and get to ride along and spend an hour in a tractor with a guy. It's a pretty small office to do business in, but I have great meetings inside the operation. But harvest is the other one. We don't have time. So we don't want to start a program. We don't want to start anything the month coming into it because we know we won't get it done. And then coming out of it, we've got field work to do. We've got fertilizer to plant, and Thanksgiving's coming up. And mom doesn't want to do it over Thanksgiving because we're planning for 2 weeks on what to eat for Thanksgiving dinner. Christmas comes right after that. And then maybe we get started on January 1st. I work with 75% of my clients from January 1st to July 4th. After that last 5-6 months of the year, very few, because we just don't have time. I also hear I already have a will. I have a plan. And that may be true and that may be great. And it may be done perfectly. But some of my best clients started already with a will and started with the rebuttal of, I don't need a plan. I already have one. I have a will. A will is not a plan. A will is a document. Your plan is inside your will if you've done one. Let's go through a very, very basic will. We call them simple wills. It's the give it to my wife and give it to my kids if she's not there will. It's usually 2 to 3 pages long, and the outcome usually works like this. So we would have a family farm. Let's call it 90 acres just for my math. And I have 3 kids, so my example is going to have 3 kids. And upon the demise of mom and dad, 3 kids inherit that farm. So you can see right now what we've done is we've divided our 90 acres down to 30 acres each. And in this case, one of them is the farm heir and 2 are not. So we have to have some sort of agreements placed that are not typically in a will that talk about leases and purchase options and how the operation is going to work, whether or not they're going to show up to work. Maybe the one needs help. Are they coming? They own some of it, or are they distant? And what we find is the closer to the farm you were raised, the closer to the farm your principals are, the more likely you're going to keep it because that's what mom and dad would have done. And because that's what mom and dad would have wanted. So sometimes this plan works in the first generation. It's the next generation we really start to see things fall apart because this generation wasn't raised on that farm. They were raised in the city. They were raised in a suburb. They were just raised in a different location. And what we have is 3 different families inheriting the thirds that were previously inherited. And what we have now is an operation that's been divided down to the point that the one person that wants to farm it only has 10 acres. We'd call that a ninth of the whole operation. So now I question your cash flow again. How does the operation work? What are the relationships between the on and the off? Are they going to just keep the farm because mom and dad said so? Well, mom and dad didn't live on the farm and they held this thing their whole life. Maybe it's time to cash in. They've got their own problems. They've got their own college education to pay for, their own mortgages, their own credit card debt. They want a fancier car. So a lot of times this is when the sale starts. And how does it work for that one farm heir to start buying everything? There needs to be some, let's call it some pre-planning. And did we get our goal accomplished at this point? Because we're trying to think from everybody's perspective. Did they get what they want? Or did we get done what we wanted to get done and keeping this in the family? So as you sit down and start to plan your family farm and start to think about different ways to do this, let's start at the beginning. Let's start at ownership, because ownership matters. How you own an asset dictates how it travels through your plan. And there's a lot of different ways. There's a lot of different directions things can go based upon your ownership. So the very simple, most basic is you own it. A husband owns it, or a wife owns it, a single person owns it, but that deed, those assets are all under one person's name. When one person owns it, it goes through their will. It goes by intestate, which is, let's call that the state version of your will if you don't have one. And sole ownership is very simple. A lot of times at marriage or during marriage, when you start your farm, when you start your operation, we add somebody else's name to it. So here's two different ways to put someone else's name on your assets, as tenants in common or as joint tenancy. Tenants in common is a 50% ownership of the whole, but not so simple that you can go out and point at that half is mine and that half is hers. It's a 50% of all. It's an undivided 50%. So every shovel of dirt, every leaf that falls, half of it is each of yours. And you can't draw a line because every leaf is a different shape and every shovel is a different size. Joint tenancy being different means we each own half, but the survivor of the two of us will own all of it. Joint tenancy travels automatically to the survivor. It works great with husbands and wives. I have sat down with families who didn't understand this, found a family of three brothers who owned all their farmland as joint tenants. They actually were some tree farmers. They had about 1,200 acres of timber, and it was owned joint tenants between the brothers. And one of my favorite questions is, before we get started, you tell me what your plan does. Just kind of a check. Do they know what it does? Do they understand it correctly? And their answer was, well, when one of us dies, it goes to our spouse, and they have to deal with my brothers. I was like, well, actually, no, your wife gets nothing. Those acres go to your brothers. Your will doesn't even affect it. Joint tenancy doesn't travel through a will. Joint tenancy goes automatic. You don't need a will to distribute it. You don't even need an attorney. Now, tenants in common is the opposite. Tenants in common sends that undivided share to your will, and your will would dictate where it goes. Maybe still to the brothers, but then maybe then to the wife. But it gave the will the opportunity. Joint tenancy never gave the will any opportunity. Then we have trusts. Revocable trusts are just one. Sometimes attorneys call them living trusts. A revocable trust is a document to own things in, to have your list of rules and future plans listed in, and they get followed through after you're gone. But while you're alive, it doesn't affect you, not tax-wise. You can get in them, you can get out of them, they're revocable. And then sometimes we have corporations. Those corporations might be LLCs or partnership, subchapter C corporations, subchapter S corporations. Those are different. They're taxed different. They have different tax brackets. They have different step up in basis. They just work different within the plan, and you have to know which one you have, and you have to know what you're giving to kids. One of the families I met 2 weeks ago and just recently started with, their family plan was all of the farm, operation, and ground is all in a C corporation. And what a great idea with 8 children to pass that down in eighths to their 8 children who can all be a part of the family operation because everybody gets along. Well, unfortunately, in our world, things don't always work the way we planned. And I never wish it upon any of us to outlive our children, but in their case, they did. One of their sons passed away. Their daughter-in-law, whom I've never met, but have heard many things about, now is asking to be bought out. This family is one of those non-farm heirs who grew up away from the farm in a city far away, and she doesn't exactly understand the valuation of the farm nor the valuation of her shares of a corporation that owns farms. And she's asked to be bought out at a number that doesn't represent reality. She's also gotten a very nice, high-priced city attorney who, and I would say, also doesn't understand how that works because they've never been on a farm. So literally by the way they owned it, they've set themselves up for a potential conflict. And we're in the process of trying to unwind, because she's gone to the FSA office and decided not to sign any papers of ownership, therefore is withholding all government payments from all owners of the corporation. And now they're there. Now they can't get any payments. So what we're doing is trying to unwind that. But the way that they owned that is what kind of created that problem. Here's a couple other ways: retirement plans, life insurance, annuities. They all go by beneficiary designation. When you set up those plans, you dictated a name or group of names to get those funds. If that person's gone, you named a contingent beneficiary who would get it if your primary is gone, and that company is obligated to give it to those people. It does not matter what you wrote in your will. You can literally write in your will, Jared Schmidt, Northeast Iowa, Ankeny, Iowa, where he lives. My favorite presenter of all time is to inherit all of my IRA. And in fact, the fact that you wrote your spouse as the beneficiary on your IRA, on your annuity, and your life insurance, I will never see a penny. It'll never come to light because the company doesn't care what your document said. We have to coordinate those things to make sure that we're giving the right assets to the right people at the right time to facilitate either the inheritance or the continuation of that operation. The easiest way for me to do it is to literally put you in a Tchart. And it may feel like you're going back to fourth grade. My son's in fourth grade. He does Tcharts. And you write down whose asset was whose, where it goes at the first death. And no offense, gentlemen, I always assume the husband dies first. Our wives are always better than us. They statistically live 7 years longer than us. So in all situations, I pretend the wife outlives the husband. So we dictate where assets go, assuming the husband dies first. But the reality is our wills are what we call reciprocal. Just in case our wife goes first, we have the opportunity to have the same list of rules in our wife's estate. So it would work exactly the opposite if it happened the other way. But for this exercise, what we're going to do is we're going to go through a whole bunch of options. And I'm going to fill this Tchart in for you with different assets and show you when things flow to the recipient, how they flow, where they flow, and how it works. This is going to become a very detailed page. And I'm just going to go step by step with you so you can see this as an example. So I'm going to update my sheet. And the first thing I'm going to go to is, we just talked about these IRAs, these retirement accounts, these joint accounts, could be joint checking accounts. It might be joint land. It could be a joint title on your vehicle. They go automatically to the joint owner. Assumedly, that's your wife. I've got one scenario. Been quite a while now. One of my clients rebuilt an old 66 Chevy, beautiful piece of equipment. He rebuilt it with his grandson. It was his pride and joy. It was in parades. It won awards. And what he's told his grandson is, when I'm gone, we did this together. This is yours, grandson. And when grandpa died, the grandson came back to grandma, all of which are clients of mine. I was able to see this process all the way through. Grandson came to grandma and said, Grandma, I know it's been quite a while. Grandpa said that, the car was mine. I'll leave it here. I'll leave it in the garage, but I'd like to go wash it. Just take it for a drive. Need to think about grandpa for a bit. So his intentions were pure. And the reality was the title on that car was joint tenants with grandma. So who really got it? Grandpa promised it to his grandson, but grandpa gave it to grandma. And the grandma understood this. In this scenario, it's a very happy ending. Grandma said, something wasn't right. Here's the keys. Let's go down to the courthouse together. Go take care of this. And they did. And it worked out fine. But Grandpa didn't coordinate the ownership of the car with his planned outcome. So assets beyond these that don't go automatic, they need to have a will or intestate. So the state's going to keep a will for you. If you don't have one, I'd prefer you did one. Inside the will, it handles the location and the distribution of the rest of our assets. And those wills, typically reciprocal, they look the same. And then here we're going to go right now and say, okay, we have our wills, but our husband passed away. Husband's gone. What happens now? Well, two things. And on the screen, two boxes popped up. What we have is the transfer of assets by will. It says, if my wife survives me, give these things to her. And they're now hers. But in that process of filing an estate tax return and going through that, those assets got to step up in basis. This basis adjustment is something you need to circle on your page right now. Not only is it a big deal for you, for your operation, it's a big deal in the news going forward. We have tax laws that are going to change. I'm not saying right or wrong, good or bad. I don't take a side in planning as to which candidate you voted for. I wait to see what they put in paper and have to deal with it. This basis adjustment, upon death, our current tax law says these assets that you depreciated, let's take a tractor, for example. You bought it, depreciated it to avoid income taxes. Upon death, we adjust that basis back to fair market value. We give it to our spouse. They can depreciate it again and avoid income taxes again. That basis adjustment is going to be in the news. You should track it. It is at jeopardy of potentially going away. It is unknown to what extent it's going away. Some of the papers that I've read said the wife will actually have to pay the gain on that tractor in order to receive it. Unknown if that's going to be the case. We'll wait and see. But that basis adjustment's a very big deal for you and for your operation. Now, sometimes we don't give things to our spouse. And before all your spouses kick me or kick each other, kick you, what I want to say is we can give them to the spouse with the opportunity for her to say, I don't want them. Don't give me that. That's a bad idea. I don't want it. That's called a disclaimer. It's a legal document that says, my husband was going to give me this, but I don't want it. So in your will, there's a paragraph that says, or there should be, that says, if I give this to my wife and she says she doesn't want it, she disclaims it, where's it go? Or sometimes you don't give the wife the opportunity and it's automatic. And what it does is it sets up a trust. Now this trust goes by many, many different names. A bypass trust, a marital trust, a testamentary trust, a disclaimer trust. There's 4 names, or a family trust is actually more common. Maybe it could be a B trust in the old revocable trusts. So there's 6 names for the same box. And that trust holds these assets. Now, why would we do that? Well, in the old estate planning world, before the word portability, we needed to have this trust to lock in the husband's credit. As of January 1, every person in America gets $11.7 million of credit. That means you can pass $11.6 million of assets to the next generation in this trust with no estate taxes. Anything over that would pay the current estate tax, which is 40%. Again, these are going to be top of the news numbers that are going to change. Is 11.7 going to stay there? Probably not. Where's it going to go to? I don't know. I would say everything we've read right now puts it somewhere in the $3 to $6 million range, probably cutting it in half to a little bit more. The tax, 40%, stay the same, maybe up a little bit. So we used to need this trust for that. There's other reasons we can use this trust, but before we decide not to give it to our wife, let's talk about what it does for her. So now let's say we've put assets in this trust. What's it do? Well, the very first thing it does, it gives our wife all the income. Do not withhold income. Do not withhold anything from her. In fact, let her run it and act like it's hers. Give her the income like it's hers. So we've not taken a penny of income away from our wife. We've not taken any control away from our wife. What we've done is put it in a box that locked in our credit, but it also facilitated management. I still run into families today where one of the spouses, not trying to be sexist, but most often is the wife, doesn't run the operation, doesn't even have a part of the operation, doesn't truly understand the operation. Therefore, this trust can appoint the next operator in charge. So maybe you're appointing your son or daughter to run the operation within this trust so the wife can continue life as normal. Just get the income, take care of the family, do what she has to do, continue her current job, continue her current role while somebody else runs the operation that's been a part of it and helping it grow. So management is one thing. Most often, this last one is why people want it. And it's a complex line. It's called protection. And if this trust is written correctly, because there's a lot of variations of it, but when it's written correctly, that those assets are protected for our wife, not from her, for her. And what that means is, let's pretend the wife has some financial issues after you're gone. She just lost her partner. She lost the primary earner. She lost the main key employee of the operation, and the operation goes south and goes bankrupt. She might go bankrupt, but she will not lose the assets in that trust because they cannot reach those assets through bankruptcy proceedings. Maybe she gets in a car accident 6 years later and there's a lawsuit. It's protected from that lawsuit. Maybe she goes to a nursing home and spends down her assets to care for herself, which, by the way, is exactly what we would do, is care for our spouse. But at the expense of the operation that the children are now running, that trust is protected from that spend down if it's written correctly. So oftentimes, and I get this call, unfortunately, I've gotten it 4 times in the fourth quarter last year, but I would say on average 2 times a year, I get the phone call that says, Jared, we've got some bad medical news. One of us is on the clock. We know the order of death. We have this many months, this many weeks. In the fact, a month ago, I got this many days, but she's still alive 30 days later. And we need some immediate planning tomorrow. So we cancel everything. We go take care of them. And what we do is we work a little bit against traditional planning. Many people say, well, if we know who's going to die, we don't want to pay all these fees at death. Let's transfer everything to the wife now. And I'm the opposite. Let's pay the fees. Let's move everything from the wife to the husband and then let him pass with it. Why? Well, because of this step up in basis. We get everything basis adjusted at that time, and we get everything into a trust like this that offers income management and protection. So now we can protect the entire operation, not half of it. We can lock in the increase in basis, even if we don't want to put it in the trust and give it back to her. We have some basis adjustment possibilities, and there's some laws in there we got to follow, some red tape we got to acknowledge, but it's there. So now what happens after that? We have all of our stuff. We have the husband passed away. We have our testamentary trust. The income management and protection goes back to our wife. But then, let's say 25 years later, our wife is able to live for a very much longer time, see our family grow, take care of them, and then their demise comes. And now we're gone. What happens next is we get our next $11.7 million credit, which, again, subject to change. Anything over this is going to pay taxes. This is where this word portability comes in, is dad had 11.7, mom has 11.7. If mom lived 25 years, her 11.7 is a different number. This acts like that would have both happened in the same year. But if they're both different numbers, we add them up. That's the total your family could have passed without taxes. Let's pretend that goes back to 3 million and 3 million. That would be 6. Okay. Now, on the estate tax return, this is marked not as portability. We didn't port our credit. It's called DSUE, D-S-U-E, deceased spouse unused exemption. So DSU is the legal word. Portability sounds a little bit easier to chat about. And here, out of order, here's the 5 advantages that came in for our testamentary trust, helping for tax inflation, probate, second marriage issues. We never did cover that. What if the husband did die very early? Statistically, husbands get remarried far more often than wives. We can't live alone. We need help. We know it. Wives often will last a lot longer without getting remarried, but it is almost a built-in prenuptial agreement between the two of you that says at the death of one of us, let's protect this. So whoever lives longer and gets remarried doesn't jeopardize those assets to the next marriage and have to share them. They stay separate. So that marriage issue does comes up quite a bit, obviously, when the wife passed first. And here's the management nursing home titles that we talked about. So after all those things, we get our second step up in basis of the wife's assets, and we have our succession strategy. This is where all of the rules we've put together come in and talk about who gets what, how the operation works, what's the cash flow going to be, and it all kind of comes together with what we've put together. So pause there and say, go back to this revocable trust. What is this, Jared? Because right now we did everything with wills. So I'm going to put the revocable trust box around what it would be. And notice I didn't change anything. A revocable trust doesn't change any of the things that we just talked about. They're identical. They're the same. A revocable trust is a box around those wills, that testamentary family AB trust, marital trust, Q-tip trust, all in there. It's all in the revocable trust. No different than it would have been in a good will. And this revocable trust then in the state of Iowa has a different purpose than the state of Michigan. Michigan, you've got a very outlined, predetermined probate process. Other states have their own processes. It's state by state. Welcome to all the states that are on this call. And you would have to look up your specific ones. Michigan's got a schedule where you look up the amount of the estate and you just calculate that. In the state of Iowa, we have to talk about a percentage. We work off 2% the gross estate. You're working with a family farm down here, 500 acres, that's $5 million. That would be another $1 million in equipment. That would be another $1 million in grain livestock. So we're talking about a $7 million estate without insurance, without life insurance, without retirement accounts. That's a $140,000 legal fee to die to the attorney. And if a bad will, it just gives everything to the wife. And then when she dies, we'll charge another $140,000. So every attorney in Iowa drives a Cadillac. They all practice until they literally cannot walk to the office anymore. I can count a dozen 90-year-old attorneys in the state of Iowa that I know. Now, other states, attorneys retire earlier because this revocable trust is much more prevalent. I would say 20% of people in Iowa have a revocable trust. And if I cross the Mississippi, 80% of the people in Illinois have a revocable trust because their probate works different. In your state, you would have to look it up and figure out that as well. That aside, privacy. We talk about privacy. When someone dies, the will is recorded at the county courthouse. It becomes public knowledge. So everything you put in there about your operation, names, addresses, phone numbers of your family, in very bad examples, social security numbers are in this probate file of all the recipients and yours. They're all published in public record. A revocable trust doesn't have that. So if you have very specific wishes, if you have things that you don't want to air the public laundry, you put it in a revocable trust so things don't come to light. My own family, much before I started this as a career, is a perfect example. I had an uncle that had a very sizable loan from my grandfather, and not a single soul on earth knew about it except those two people, and it became public knowledge. So that's a little bit of a shock. I'm sure he didn't want that out there. Grandpa would have been better to have that part put in a revocable trust and kept it in the family because that's what he did for the 20 years they had it. Why should it change because he's gone? So now With this revocable trust, every attorney has a different way of drafting it with very high exemption levels. Right now, that's the $11.7 million. It's very common to have a joint revocable trust where you have one document for both of you. Some attorneys go the old school way, or if this credit goes down, we'll go back to having a husband's version and a wife's version. So you have two revocable trusts, just like you have two wills. So there's your dotted line down the middle. And all those plans come together for the farm heirs and the off-farm heirs. Now, let's go back a step. Let's bring mom and dad back. Because everything we see here is done during life. All these rules. Now, the outcome is not done because you're alive, but all the rules are inside your trust or will. They're all there. All these things should be present in your documents, all these plans in your documents today, so that they can be followed through in this succession strategy to those heirs. And just for the sake of argument, just to try and create confusion and maybe solve confusion for a few of you, I'm going to add another type of trust to this page. You thought I couldn't fit anything more on it, but I did. There are irrevocable trusts. What's the difference? Because these are often misspoke. Revocable means I can undo it. I can get out of it. I can draft it this year, get in it. I can hate it next year, get out of it. I can find a new one 3 years from now and get back in it. There is no tax consequences to any of that. And irrevocable is the opposite. It is a separate entity. Think of it as a third person. It has its own tax ID number. It has its own set of plans that need to be mirrored with your plans so that you can't use it as a bypass to get past the plan. And you know what people throw in it? Once you put something in it, you can't use it anymore. So you don't want to put any part of the operation in it. You don't want to put farmland in it. You can't have that anymore. You can't even have access to that anymore. You can't have any quote unquote enjoyment is the tax term of that asset anymore. So what's the one asset I know you probably have a little bit of that you don't ever get enjoyment from? Life insurance. When you die, there's a check written to somebody, but it's not you because you're gone. So oftentimes we put the life insurance in the irrevocable trust because I know you're not going to get any enjoyment out of it and you're not going to get any use out of it. Someone else will. That helps get it out of our estate so that if they bring down our credit, it's not counted against us. And some of you right now are saying, wait, Jared, you're talking about our credit. That helps dictate a tax. I thought life insurance was tax-free. Well, that's a half-truth. It's income tax-free. When you bought it, somebody told you it's tax-free. It's income tax-free. It is 100% subject to the federal estate tax system. So you could have $1 million in assets and $12 million of life insurance, and you're paying estate taxes. So now obviously 12 million in life insurance, who has that? We're not worried about that. But if life insurance is the asset that puts you over your credit, there is estate taxes due. So that life insurance can become, now mom and dad are gone again, and we have all this plan put into place. That irrevocable trust has cash. And it can be used as a predetermined equity or balance maker or used as a buyout to help facilitate the operation to the people we want it without having to take it off the inheritance list of the people that want it but don't want it as much. We're going back to that group of grandkids or kids that are off the farm that aren't going to show up for work tomorrow so that we can get the operation of the people that do show up and an equal or different asset to the people that don't want to, so that we don't feel like we took something away from them. And there's our arrows that put it in there. So now this page, if you screenshot it, everything that I'm going to put on it is on it right now, but it is a step-by-step kind of a roadmap to a lot of things that we use every day in estate planning to help build that succession strategy. And if you want to print it, you want to re-listen to that's great. Use this as the roadmap for a lot of the tools. What's available? That's all available. The succession strategy is a family conversation. It's either operation driven or relationship driven. And we got to figure out which one of those succession strategies goes in there based upon how we want it to go forward. So a couple quotes that we use. The second guy, you're going to recognize his name. The first person, you have no idea who that is. That is actually my partner's mother, not somebody you've ever met. But sitting down to do their planning before he was a partner, we laid out some options, and they were too busy already. They didn't know what they wanted to do. And Marie looked right at him and said, if you decide today not to decide, you just made your decision. She knew he wasn't going to go back and do it. If he decided he wasn't doing it today, it wasn't happening. Well, that resonated with him and everybody in the room. And he said, okay, let's do just enough. Let's make sure it doesn't fail, but I'm not ready to go through the whole deal and get all this stuff done. So they did just enough. And thank God they did. 6 months later, that straight truck, the grain truck, caught a soft spot in the ditch and rolled that truck on top of him. He's gone. They did just enough to make sure that that operation worked, so that today that is still a successful farm operation. It's farmed by my partner's brother, and it works very well. And because we did just enough, my partner is still an owner in some of that. He's that off-farm owner that knows his dad would have said, don't sell that. You rent it to your brother and you take care of him. And that's what he does. What will his kids do? I don't know. We'll have to wait and see. The second one, this is more of the fact-finding stage when you're asking yourself, the more information you have, the more obvious the correct decision becomes, and therefore an easier decision to make. And Dave Ramsey said that. And what that means is putting your goals down on paper so you know what your goals are, so you know what the income is, you know what's required of the farm to have enough income, because we can't add mouths to your operation nonstop without adding profit, because every mouth is another plate at the dinner table that's going to eat but didn't necessarily go out and harvest. So make sure we have all those things. And when we do, we have to go do it. We sit down with trusted advisors and we say, what documents do we need to accomplish this? What are the things that have to happen? Whether they're wills and trusts and entities or buy sells, and when does it need to be updated and reviewed? We go do it. And then we decide who to share it with. Do we share it with no one? I've got families like that. Do we share it with just the important ones, with the executor, the trustee, the power of attorney? Or do we share it with everybody? My only recommendation is when you share it with everybody, or even if you share it with anybody, cross the numbers out. The numbers will be different. We don't want to put a number in somebody's head that makes them think of that number instead of the plan. Share the plan and tell them numbers change, values change. So maple tree growers, I don't think that the value of maple syrup changes nearly to the extent that the bean market changed yesterday, or the corn market changed, or the hog market going the opposite direction of both. So all of those numbers are different, but your land values do. When the right or wrong person moves into or out of your neighborhood, your land values changed. Or the city is growing out to you and all of a sudden the best use of your property is not for what you're using it for. It's to build Walmart, and they offer $2 a square foot. Well, that's 43,000 square feet, $2 a piece per acre, $86,000 an acre. That's happening. I don't know what they pay in Michigan, but that was offered to my client 6 months ago by Walmart. So then you have to review it. Things will change. Those people move in, they move out. What we have is we have kids that leave and then come back, kids that stay and then want to leave. We have political offices changing, the taxes, the process, the forms. Our 1099 forms changed this year. Learned that last week, and I have to do 25 of them yet. So everything can change, and we have to make sure we draft a plan that is flexible, that we can continue to adjust it. We don't want to etch it in stone unless we are absolutely sure that's what we want to have. The operation can change size. You know, Grandpa used to say, that farm across the road comes for sale once in your lifetime. If you don't get it, you'll finish your lifetime watching somebody else farm it. So what does that guy do when the farm across the road comes for sale? He buys it. Now, today's world has meant that we can farm further away. Grandpa would have never dreamt of driving 2 miles down the road to farm another farm because of the equipment and what he worked with. But gosh, the old Oliver 1655s, that's what he had, and the newest in the neighborhood at the time. But he wouldn't drive it 2 miles. And today, driving 25 miles happens all the time. Loading things up on a truck and driving them halfway across the state, it happens. I know a few guys that still do it. The operation will change control. We'll have people that decide to bring controlling parties in, meaning let's let the son start making decisions. Let's turn over this part to the daughter who's doing a phenomenal job. And we have some control issues. And then the stage of your life, 62, 65, that's when people in town start to think about retiring. I don't have that many farmers that retire. I have many that die on the farm. I unfortunately have more that get found in the cattle lot than I do voluntarily walking away. When all those things happen, does it still work? So we started this, and I'm just about ready to wrap up. Looks like I'm doing good on time, I think. What was your perspective when we started? A man without a woman is nothing. What's your perspective now? When you learn different ways to look at things and you learn different things that you have to deal with, different thoughts and possibilities that have to go into this type of planning, you have to have perspective. Is that perspective nowhere? Is it still a hurdle? Do you still have roadblocks? You need to find your roadblocks and knock them down. Does it help give you that proverbial kick in the pants to get going? The opportunity's here. I've got some knowledge. It's fresh in my head. Let's go take care of it. Have perspective. Have the perspective that you need for your operation, for you and your wife or your husband need for the two of you, because it's your plan. You can do anything. It's all there and all possible. And the perspective of the kids, what are they going to think when you get what you want? And it's not exactly what they thought. Does it matter? Are your goals accomplished, or are you doing this for their goals? And I know families on both sides of that. And it's not for me to tell you which is right. It's for me to tell you that you can do anything you want. The tools are available. As I finish up, I wasn't going to go through this entire screen, but questions you have to ask yourself as you begin to do your process. Who are the decision makers, and do they need control? What are the assets and who needs them? Really doesn't make sense to give the assets that are needed to somebody else who's not going to use them, or just try and sell them back to the person that does. And we can't control that sale price, or can we? We can't force them to play together, or can we? We can't force them to play nice. We can force them to play together. When should all these things happen? What's your time frame? You going to wait till someone's gone, or are you going to do it in life? Sometimes cash flow dictates that. Sometimes taxes dictate that. And then communicate it. Who are you going to tell? Take the action and start it forward. I would say your attempt at a plan, even if it's not a perfect plan, is far better than no plan. So do your best at doing what you can. Open this up for conversation, open it up for questions. Hope it at least provided a little bit of background and some information to you. And again, best of luck in your process. I would make myself available for questions, or if somebody wanted to reach out to me, that's fine. Obviously, today's world's a little bit different. I don't travel to Michigan very often. Been there a couple times in the last year. I do have a Michigan dairy farmer as a client, but the world we live in now has forced grandma and grandpa to learn how to do Zoom and FaceTime because they wanted to talk to their grandkids, and we can't go see people. So Zoom, and I can sit right where I'm at and help you over a screen, is also an opportunity. Thanks very much for your time. I hope the rest of your day goes phenomenal. look like a nice day behind Jesse. And
Great.
Good luck.
Hey, Jared, thank you. For those on the Zoom now, we have the Q&A open, and we have time. And if we run into that 15-minute break, that's great. This time is really for you. This normal session that we have, Jared, this hour-long session, I remember the first time we did it, I think it went 2 to 3 hours. And so I've asked him to boilerplate it down to an hour with questions. And so that's really hard to do. And I appreciate the content, Jared. From my perspective, knowing the demographics of most sugar makers, it really was meant to scare most of you and to really make you think about estate planning. What he talked about with equipment and land, we all have that. And I guess, how do we make sure that things, I remember in one talk, Jared, where you were like, what is fair and what is equitable? And it's the off-farm heirs, and how do you make it so that you can continue that operation into the future? And so this is a really important topic, and one that we really don't like to talk about. And one of the questions that came in, Jared, is where do we, it says references made to the fact that each state handle ownership transfers differently. And where do we go to look for this information in our own state? So is there a common area that we can go to find out how the state handles these transfers of ownership?
I really wish it was an easier answer than what I'm going to give, but it's all in the state bylaws. So you would have to sift through them. I would guess a Google search will get you really close. A conversation with an attorney might get you the actual language. In preparation for some of this, I did reach out to a couple attorneys I know for some favors and just got a little background on Michigan's laws, but unfortunately I didn't get Illinois'. But it is all listed in the state bylaws, and some states have other ownership that I didn't list. An example might be tenants in entirety is something we've run into in some of the southern states, and each state might recognize an ownership that another state actually doesn't, which didn't answer your question, but maybe compounded it. Mm-hmm. But it is all listed in the state bylaws, and Googling Illinois bylaws, ownership distribution or ownership transfers might bring that up. So I wish it's something I could just copy paste to you, but it's not. And I hope that's not a lengthy search.
Okay. And so I also had a question. First, for any attendee out there, if you have 11.7 million in assets in a maple operation, I am first and foremost up for adoption. But also along that line, let's say that tax, I don't even know what the right term for that 11.7 million figure is, but let's say it does change. Let's say it goes down to 3 or 4 million. But the first death happened when it was 11.7. Are you grandfathered? Is that rate grandfathered in?
That's a great question. And I'm going to give you a little bit more context. We're less than 15 years away from when that was 600,000. That's how far it's been escalated. So 15 years ago at 600,000, that's a different number. Now valuations and everything were much lower just 15 years ago, but it's been moving up and up. And if it goes back to 3 million, if you're alive, you have to go back to the $3 million. That's your new law. At death, the IRS has already issued private letter rulings that said they will not claw back that change. So a death that occurs at $11.7 million, they would be able to port through portability or DSU whatever was unused to their spouse, and their spouse keeps that number. Only their spouse's living number goes back to 3, but you could very well protect 2 million in assets and have 9.7 ported over to the surviving spouse. They can then change that new law to whatever they want because the wife is sitting on 9.7 plus whatever she gets for the new law. That is considered to be law through an IRS private letter ruling. This country has never gone backwards and moved down the estate tax. with the exception of a 2-month period at the end of 2010, when we went to 0 estate tax and then instituted in March a new estate tax. I guess that would be going from 0 down to 5 million, would be considered going backwards. It's the only time in history it's happened. Actually, that's when George Steinbrenner died. Several $billion of the New York Yankees made it through the system tax-free. So convenient timing for him. Well, maybe not, but you get to keep what you have if someone died.
Okay. Great. I have another one. John asked, do you recommend or have any favorite reading materials, books, websites to help us get started with the estate planning topics that you discussed today? How do we start the process? Is there just a very simple form that people could start filling out to get them to think about this?
Gosh, we create forms to help fact find and set goals and try and ask leading questions that would make, hopefully difficult questions that would make you think about outcomes. But most of the reading that I come across was written by an attorney and therefore gibberish or Latin, and becomes very challenged readings because attorneys like to go into very high level of detail, quoting laws and justification. So to be honest, I've not read any, let's call it table level books or releases that would help somebody understand it. Maybe because it's so family specific in terms of the operation, and every family is different. So even if an attorney said, hey, you got to do it this way, there's going to be 90% of people that say, but if I do it that way, I make this person upset. It doesn't work. So I would say asking difficult leading questions about the future of the operation and what realistically is expected is the way to start, and say, do we want this to be an operation? Do we want it to make money for our kids? And I did read the comment up here that said somebody acknowledged the best use of their ground is not for what they're doing with it, it's for development. And they'd like to see it stay in the family and do that. So you got to convince a bunch of kids that the operation is more important than the paycheck. And your documents can force that on them, and your documents can suggest that to them. And I guess it comes down to those two. You force them or you suggest it. But in the end, you either dictated it or they decided. Difficult to stomach some of those some days.